move over and spend a few minutes talking about the enforcement and repudiation powers. And we're talking about enforcement now. We're talking about the enforcement of contracts. It's the provisions of 1821E13 in particular. As I think was mentioned earlier this morning, there are a lot of contracts out there that have default provisions that are triggered by an insolvency of one of the parties, ipso facto clauses. They've been the subject of litigation in bankruptcy. We had issues with them in the early to mid 80s before FIREA, and so in FIREA there was an attempt to cure that problem and basically provide that the FDIC as a receiver could still enforce a contract or essentially require performance under a contract notwithstanding such a clause. It doesn't excuse performance on either side for any other reason. It just says that they can enforce the contract if they choose, even though the institutions become insolvent, and that would have triggered a default under the terms of the contract. It's really pretty much that simple. I mean, it's directly targeted at that particular issue. If the contract is repudiated, your damages are very limited. As I said, if you have damages related to pre-appointment, those are going to be whatever they are, they're going to be a general unsecured claim in the receivership. They're going to be limited to actual direct compensatory damages, whatever that means, other than it was as long a string of adjectives as we were comfortable putting together at the time. Determined as of the date of the appointment, and essentially that means you're not going to be able to get obviously punitives and those kind of things are out the window, but you're not going to get compensation for lost profits or the other, if you have a service contract that was supposed to run for 5 or 6 years for some kind of processing function or those kind of things, you're not going to be able to present value that payment stream. Leases are treated pretty much the same way. You don't get to say, well, I would have had this income stream over time, and therefore I'm entitled to these damages. What you may be able to do, and this may be where some of the litigation in the future gets into, is if you entered into a service contract that required you to go out and obtain specialized equipment, you may be able to argue that but for the contract you would not have obtained that equipment, and therefore that is an actual direct and compensatory damage to give you a claim for that amount.